Let's go to Eugene. He's on a mobile phone. Eugene, you're on News 96.5. Go ahead.
Hey, good morning, Tom and Rob.
Good morning.
Just wanted to put a perspective. I was thinking about it. I've been listening to this trial now since its onset. And, people are jumping to conclusions much earlier than I feel that they should be. And the reason I say this is because, I'm a former law enforcement officer. And one of the things that I see in a case of this magnitude is the technical perspective of it. And I think more issue is in regards to who was the aggressor is going to be brought into this thing, because if there was an aggression and there was a fight, and the other person, or let's say Mr. Zimmerman was aggressive, was the aggressor, and he got into a fight, then it becomes a point of, at what point does he have the right to use deadly force? That's my concern. Is at what point is deadly force feasible if he was the aggressor and this situation took place? Where do we go from there?
Thank you, Eugene. I think that's a very good, fascinating comment. So here's my thoughts on that. I think that it is human nature to jump to conclusions. It is human nature to use your imagination to fill in the blanks. So we've all, to some degree, have done that. Now we're getting new information that hopefully we can substitute the new testimony and information we're receiving and throw out our imagination and work with what we now know and what we will know some more about. The other thing I remember about early on is that George Zimmerman was saying that at some point in time he's scuffling with Trayvon. He believes that Trayvon sees the gun in George's pocket or holster or whatever, and believes that Trayvon's next move is to go for that gun, and George went for the gun instead. So, Rob, your comments.
All right, let me start with the first part of this, which is, I think, very insightful and very true, which is we just know so little about this case, and we're learning how humble we need to be about drawing conclusions about it, because all of us who read newspapers and have opinions and are lively, interested human beings would have thought about this and possibly drawn some conclusions. What I've learned is, boy, there's a lot of this I don't know. There's a lot more testimony, a lot more information that I don't know. So I share Eugene's concern and observation that we ought to be careful jumping to conclusion. Particularly, I expect the forensic evidence to come out that will give us a whole new set of data upon which to base our conclusions.
Hey, by the way, our time is just flying by, Rob, but we're going to have to go to a hard news break here in a few minutes. But we have Susan, Brian, and Keith on. And our first caller today was about why not a 12-person jury versus a 6-person jury. And we covered that. But what I didn't get was your thoughts about, wow, 6 women on this jury, 5 of whom are white. Mm-hmm. Ooh, boy, who is that working for and who is that not working for?
Right.
And I'd like to get your thoughts on that when we come back from the break.
Okay.
Hey, folks, remember that we have lawyers in my office standing by if you talk to you right now. If you've got the real estate questions, divorce questions, bankruptcy questions, other things other than George Zimmerman, you can call my office right now and talk to a lawyer at 407-423-5561. My name is Tom Olsen. The name of the show is Olsen on Law. You're listening to News 96.5.